Assalamualaikum warahmatullahi wabarakatuh and hi everyone. My name is Nur Afifah binti Azami. My metric number is 056815.
Assalamualaikum and hi. My name is Anis Akira binti Ashbakri and my metric number is 056796.
Hi, my name is Wan Ahmad Firdaus bin Muhammad Nazir. My metric number is 056387.
In this video, we will discuss the maxim of equity will not suffer wrong to be without a remedy and whether it triggers the development of equity law. Before going in depth into our discussion, we need to know its historical development, where in the year of 1066, William, the Duke of Normandy, defeated the English army under Anglo-Saxon King Harold Godwinson. Consequently, the Norman conquest has radically affected the English language and culture. Thus, by the year of 1080s, the Normans established well-organized counties that administer local law and set up local courts. The period from the Norman conquest until King Henry III's reign in the 13th century had witnessed the rapid growth of the common law based on customs of the country. A person who wanted to bring an action had to go to the chancery and obtain an appropriate writ after paying the fees. However, there were some deficiencies in the common law practice, such as he was not be able to provide a remedy if a person's cause of action could not be brought under any of the recognized writs. The relief was not always adequate, and the procedure was also too rigid and formal.
The maxim of equity will not suffer wrong to be without a remedy, or ubi jus ibi remedium, is defined as where there is a right, there is a remedy. It serves as an equitable treatment where in some instance money cannot be paid for the damage received. This maxim had been said to have kick-started the development of equity in common law, as in some conditions the remedy provided by the common law is not giving justice to the lawsuit to the parties. This maxim is known to be the root for all equitable jurisdiction. It fills out the area where the common law fails to provide. The principle of equity has shown its significance in giving injunction to enforce new intellectual property rights. The maxim can be seen concerning three different types of equitable jurisdiction. Firstly, the original jurisdiction. The trustee is known to be the property's absolute owner and email deals with it with however he wants to do, while the property's beneficiary was not recognized or of his right according to the common law perspective. However, in the eyes of equity, this is wrong. Equity forces the trustee to hold their property to the benefit of the beneficiary. Equity enforced on the trustee are also against the transfer from him with notice of the trust. Next, the concurrent jurisdiction. Common law only provides the award of damage in breach of contract cases. This award is insufficient to the claimant, especially in violation of a sale and purchase of land. Under equity, it provides an equitable remedy of specific performance that enforces the other lawsuit party to perform the contractual agreement. Other than a breach of contract, it is also applied in the tort of cases. Equity will provide an injunction to ensure the claimant's right would not suffer further invasion. Lastly, the supplemental jurisdiction. The claimant will assist in enforcing their legal rights. The common law does not have the power to order discovery of the documents in possession of a party to the action. However, the Court of Chancery did make such order and caused wrong not to get remedy. At common law, a judgment creditor cannot impose an execution of any property of the judgment debtor. The latter had only had an equitable interest. The common law cannot touch equities of redemption or a beneficial interest in a trust. The Court of Chancery applied a procedure where fair execution could be imposed on equitable interest by appointment of receiver of equitable interest, supplemented in appropriate cases by an injunction restraining the judgment debtor from disposing of the claim. We can see how this maxim is applied in the case of Tengku Reza Shah bin Tengku Shahrizad Shah against Asiapura Land Sedar Berhad. The court in this case had followed the decision in Badiadin's case It follows on no one is entitled to the aid of the court of equity when that aid had become necessary through his or her own fault. Equity does not relieve a person of the consequence of his or her carelessness. A court of equity will not assist a person in extracting himself or herself from the circumstances that he or she had created, and equity will not grant relief from a self-created hardship. Court decided that they find nothing of the act that are of the defendants or the plaintiff doing. Thus, the doubt's benefit were given to the plaintiff.
Due to the deficiencies of precedent-based common law, equitable remedies were developed by courts of equity. Equitable remedies differ from legal remedies that were granted based on the court's discretion. Various types of equitable remedies are available from the court of equity. These equitable remedies are superior remedies rather than those administered under the common law. The two main equitable remedies are specific performance and injunctions. Specific performance is a function in requiring a person to perform his contract or statutory obligation. It is an equitable relief given by the court against the defendant to enforce the duty of doing what he agreed by contract to do. This remedy would be particularly useful where it has the effect of ordering a contracting party to do what he has undertaken to do, whether in writing or not. It is also ideal for enforcing an agreement for the sale and purchase of a property, including delivering a strata title. Next is an injunction, where it is an order from the court to a party to do or refrain him from doing a particular act, either the beginning or the continuance of the act. It is a preventative and injunctive relief at a pending trial, addressed to a specific person, either prohibiting him from doing or continuing to do a particular act, or orders him to carry out specific actions to protect the plaintiff's interests. When the court grants it, the parties must observe the terms and bound by them, because if they fail to do so, it would constitute contempt to court. The other variety of equitable remedies include rescission, rectification, and other remedies under the Specific Relief Act 1950. These are various types of equitable remedies available from the Court of Equity at such court's discretion, which have different effects and consequences. However, the application of this maxim has certain limitations through various case laws. For example, suppose there is a violation or breach of moral rights or political wrong. In that case, it is not considered under this maxim, as they are not actionable or not recognized by law. It should be applied when legal rights exist and not of any moral, because not all moral wrongs should be redressed by equity. The same goes happen in the case where, due to his negligence, the aggrieved party either destroyed or allowed to be destroyed evidence in his favor or waived his right to an equitable remedy. Therefore, the maxim cannot apply in court. There is no application of this maxim in the cases where both the right and remedy were within the common law court's jurisdiction. You can refer to this case. So, this maxim cannot be applied to cases that have got proper remedy under common law. In the case of breach of marriage or any personal promises as a personal commitment, no remedies are available under this maxim, because these are the promises made without consideration and are based on a fiduciary. You can refer to this case. At first, in this case, she succeeded in her claim, but the Court of Appeal held no contract between them, since they did not intend to attend the agreement by legal consequences. The promise made by the husband to his wife is not enforceable in the court of law, because it was not made to create a legally binding contract. Therefore, this maxim does not provide a remedy to breach of contract, oaths, or any personal commitment, as these all are promises made without consideration and are based on trust. This maxim does not apply when no legal damage or injury has been caused to any person. However, if any of his fundamental rights were violated by any civil wrong act, therefore, the plaintiff had the right to go to the court of law. Such right is legal, but an exception to moral or religious rights, since they are not actionable. By referring to this case, in this case, the court held that no damage was caused as the candidate that the plaintiff wanted to vote won the election as a defense by the defendant. However, to restrain a person from giving a vote is a civil wrong. Therefore, the plaintiff here had the right to seek a remedy from the court because of the infringement of his legal right, though he did not suffer any monetary loss.
In conclusion, we from Group Amigos are all agreed with the statement where equity will not suffer wrong to be without a remedy is the maxim that expresses one of the core factors that triggered the development of equity to aid the common law that lacks sufficiency and appropriate remedies. There is no doubt that adopting this maxim into the court's practice in serving fair justice is appropriate. Also, the rights and remedies provided for the claimants become more stable. Besides, maxims of equity are not a fixed set of rules, but the general principles derived from specific cases subject to the judge's discretion. That's all from us. Thank you.